Hello. हेलो
जी सर। सिर्फ जस्ट अ मिनट वेट करें। अब यूट्यूब पे लाइव जाते हैं तो आपको इंशाल्लाह स्टार्ट करवा
ओके
देंगे।
ओके ओके I'm waiting. It's okay.
जी सर, ठीक।
Assalamu alaikum everyone. I hope you all are doing great. So the meeting is now in session. I'm Sonia Imtiaz from Ladkhana. I did my LLB from Shahid Benazir Bhutto Law College, Ladkhana, and I am the General Secretary of Dynamic Law Association, Ladkhana team. I have sent my first intimation and I am underprivileged now. So, as you all know, our 4-month trial advocacy course is going great. This course is aimed to sharpen participants' courtroom skills, master advocacy techniques, and building legal confidence. So, we are honored to introduce Mr. Ghulam Shabir Babar as the speaker of our 5th lecture of Dynamic Law Association Trial Advocacy course on the topic Labor's Law. Mr. Ghulam Shabir Babar is the sole partner of Babar Law Associates and a highly accomplished professional lawyer, academician, and international consultant specializing in immigration, corporate, and commercial matters. Since 2004, he has been actively engaged in litigation practices spanning criminal, civil, constitutional petitions, service matters, mediation, and the ADR. If we're talking about his educational history, academically, he is a gold medalist in economics from the University of St. Jamshoro in the year 1996-2000 and a law graduate from Hamdard School of Law, Hamdard University, Karachi in the year 2003. He earned the prestigious Erasmus Mundus Scholarship to pursue an LLM in the Law and Economic at the University of Belgium, Italy, and the University of Ghent, Belgium. Under his leadership, Babarla Associate has partnered with Karma Developers and is an associated partner of Erasmus European Masters in Law and Economics program. Mr. Babar Saab has also made remarkable contribution to the academia as a visiting professor of law at a government Peer Elahi Baksh Law College, Tadu. Shahid Zulfikar Ali Bhutto University of Law, Karachi, the University of Sufism and Modern Sciences, Birsha, and the University of Karachi. He is currently serving as a foreign attorney at the office of Manuel B. Conchal in New York, USA, and as a barrister and solicitor with the Canadian Society of Law. So, with the honor, I would like to call upon Mr. Ghulam Shabir Babar Saab. Sir, please start the session. Assalamu alaikum, sir.
Walaikum salam. Ji, Sonia, thank you very much to invite me in this very important subject. It's a labor law, and labor law, is a very special practice. A special law. And we are practicing, civil, criminal, constitution, and corporate, and there are a number of the fields. And it's most and little bit the student they join in the labor law. It's a law relating to protect the workmen, labor's rights. And they are suffering while working in the establishments, factory, and the very little shops, number of the fields, and initially this is the law, it's a number of laws were developed, before the partition. There was the Factories Act 1934, Industrial Relation Ordinance, which was is 50 years. Pakistan was enacted ordinance, then became a law in 2002, the Industrial Relation Ordinance 2002. Then it became, Act in 2012. And the main feature of the labor law is to protect workers' rights and also ensure fair employment practices. Because the weaker is the labor, when he employees there, he get employment, and then he is joining trade union, and join association as well. So yeah, now I'm going to discuss on the Industrial Relation Act, and this is then my second part would be practical perspective, how to file a petition, how to appear before the approach to the labor code or the industrial relation commission, so to seek his right and force, against the employer. So I'm going to start with the law. This is the, Industrial Relation Act. There are the 10 chapters, Once first is the preliminary. The preliminary section I told you earlier that this is the law relating to regulate the laborers, how they are practicing, and the first chapter relate to the registration of trade union and trade unions, how to register, where to register, and the registrar how to file an application if there are one or more trade unions, so then which can be considered, how to file an application. These are the administrative, issues, you can look at, and then there is a chapter definition clause. Being a professional lawyer, you have to understand the definitions, which falls workman. And in the initial, if I say something, then there are the three very important aspect. One is which court has a jurisdiction to avail or approach to the court, which court has deal to the labor laws. There are two parallel, the courts. One is the labor court. Second is NIRC, National Industrial Relation, Commission, and both parallel look at, but the difference is if the company is registered inter-provincial, the Punjab, and the office is one of office in Sindh, then the labor has, workman has right to approach and approach to the National Industrial Relation Commission, single bench, and under section 31, and he has to file a petition and related to his employers, we can say that the unfair practices. And in section 32, as well as the employer has power, his right to file, petition against the workman that he is restraining, he is locking out, and he is striking the business of the company, or there are the chapter number 3 is a collective bargaining agent of both sides. Section 19 relate to the collective bargaining agents. Then the function and the purpose of the collective bargaining agent, which is one is it's looking the affairs of the establishment, company, or factory, and then the second is a collective bargaining agent, the trade union. So appoint the agent, one of the two. They represent workmen in different forums. There is also provision related to the check off and the workers' participation. I told you there is a section related to chapter 4 is settlement of disputes. There is also concept of arbitrator. The very important in the before that there was no arbitration, clauses and the conciliatory clauses, in the Industrial Relation Act 2012. And the section has been embedded and added. and the settlement dispute or redress of individual grievances related to, the there is some issues related to workmen's, hours, working hours, minimum wage, leave entitlement, workforce safety, and the social security benefits, And the, I told you there is also the authority. Authority means Workmen Compensation Act. There is authority. There is authority payment of wages act. Authority is a separate, There is authority is a social security, and these are the parallel, dealing with the different aspects related to wages, related to leaves, related to workforce safety and security. Here we are talking about if workman is misconducted, and the how to protect, how to initiate is against the employer. What they do that they send the issues in show cause, and the show cause issued, and the time is to be framed that he has to or she has to reply, and the reply, if the employer is not satisfied, then the charge sheet will be issued, and meanwhile the charge sheet issued, and then the inquiry officer would be appointed to conduct an inquiry against the allegation against him, late coming, the misbehaving with the officials, internal issues, look at same, if he found the company or establishment found that he has misconducted, then what the company do that? The company send them the termination notice, and the termination notice, and when he received the termination notice, then what he has to do that he has to under section 33 RA, Industrial Relation Act, he has to issue a grievance notice, and the grievance notice to the company that the whatever allegation against him has been proved, which is to be informed, and it is not justified, then within 15 days he will send a notice to grievance notice to company. Then if he receive a reply that the okay is not satisfactory, it is the against the policy or rules, then the employee or the workman has a right to file an application or petition before the NIRC. NIRC means, I told you, there are the two jurisdictions. If the company is registered within the province, then the workman will approach to labor directly, but the procedure is same. I'm telling you that the 15 days notice is to be issued, and then he has to wait for 60 days of the reply. If the 60, before the 60, yes, I will give the reply, and you hold on the question. Each and every question will be replied, and after, because we have the short time and 20 minutes remaining, so within 5 to 10 minutes, 10 minutes would be the sufficient for the answer. There is no issue, and I would be available. My number is there, and we can connect via WhatsApp. There's no issue. And let me complete. Then I will. Then 60 days, the employee or the workman has to approach to NIRC and file a grievance petition. And the grievance petition is saying all the the notices and the reply and all the documents and his employment letter and whatever the annex he has to annex it. And there is a draft, how to draft it. And the same procedure is a procedure under CPC, we will follow. Then he will file a plaint along with the annexes, of his employment letter and the what he received notice and a reply and the additional document what he is possessing that, and each and every document has to be annex A123 A1 A2 A3 B1 B2, then the company has to after filing an application or petition, the notice is to be issued to company or the factory or whatever he is employed. And then the reply would be in 30 days, and when after replying, then the single bench of NIRC or the labor judge will ask to submit a affidavit evidence. Affidavit is reproduce. I say that I was the employee, I was appointed, and my salary was there, and and each and everything, and he has to write he has to narrate the whole case. Then the affidavit evidence, he will file affidavit evidence, and after filing evidence, the company's lawyer will cross-examine him and him or her. Then the side will be our witness. If there is a witness of the workman, he has to produce, and then he will give us some, maybe the trade union, collective bargaining agent or employee of he's seen the incident, and then his support is, So then the site will be closed, then the site closed after that. Then the company will file affidavit evidence, and then the representative of the company will be examined and cross-examined. Then the site will be closed, and the site after that, the formal arguments. Then the bench will, the labor court will decide the case, pass an order, we call the award, and if someone agreed, the company or the labor is workman is agreed dissatisfied, then there is also the full bench under 54. So he has the right to file an petition appeal. Then the labor tribunal, there is a I assume the labor appellate tribunal, then within 30 days of the time period is provided. Then appellate decided the where the this is the law, there is a remedy in the appellate after that, and then if company or the workman is dissatisfied with the tribunals or full bench order, they can file or he can file the petition before the Honorable High Court under Article 199 of the Constitution that there is no adequate remedy available. Then the Supreme Court, this is the procedure. I told you that, and very important in this the labor law, that there is an industrial dispute, and there is the reconciliation, there is the arbitration, and there's the wages issue. There's the there is also formation of trade union issue, award issue, and if misconduct has been made, and there is a procedure to file an appeal under Section 55, the finality of order, enforcement of guarantee and powers of and the prohibited, and the representation of body, and there is a penalties, and this labor, it has been against it is filed at penalties as well can be imposed under Section 67 and the labor practice, and the very important issue is the redress of industrial grievances, Section 34, and also the unfair practices of both sides. Okay, this was my general view, and you can I'm welcome to your answer and your questions. Okay, Muskan has okay. May I request you to kindly okay. This is if an employee is terminated without being a copy of the termination, what legal? Yes, what if he has not received the verbal? He has Abdulaziz Samtu, he has received the verbal termination. Then okay, you can file, there's, I told you the representation, this the grievance again, okay, 15 days notice is to be issued to employers that why I have been terminated. You can ask, and if they cannot give you, then you can also directly file. Don't wait for the employer's response. So you can file. Okay, I have been. There is an interim order as well. You have not received the order from the employer. Then you can approach to the NIRC and file a petition. There is an interim order, section 54, and the interim application be filed. Then you can claim. You can approach to the labor code as well as NIRC, that approach that they may be restrained not to restrain me, not to, they may be directed to issue my monthly salary. And okay, any question, I would be very happy to give you the reply, and and if you need any further clarity, you can ask me. Okay, I'm waiting. Thank you very much for your patience. And
Sir,
okay.
lecture continue रखें kindly.
Yes, I'm waiting for the reply and the questions. I'm waiting. It's okay. Okay. Yes.
Assalamualaikum, sir.
Ji, Waalaikum Salam. Ji.
Sir, this is Muskan Rahman. I'm third year law student from Shenzhen, Karlibutto, and currently
Yes.
serving as an information secretary at Dynamic Law Association, Karachi. Sir,
Yes.
first of all, thank you for the insightful session. And I will request the audience, if there is any question, you can ask from the sir.
Yes, shoot it. Don't worry about Urdu, Sindhi, Korean, Saraiki, and you are allowed to. This is a confidence. You have to ask. I would be very happy to discuss. And it's a learning process. And this is nobody's complaint. You can ask me irrelevant. I would be very happy. There's no issue. Okay. Come on. Participants are sleeping. I don't know. Okay.
Sir, there is a question from the YouTube. What is the
Okay.
forum for the regular contractual project types employees pursuing?
Can you repeat it? What did you say?
Sure, sir. What is the forum for the regular contractual project type employees pursuing?
Yeah, it's related to contract. It's a contractual project.
Yes, sir. It is a contractual.
Yeah, basically, the very important. This is in employment. Any employment, whether this labor or the service, there's no concept of contract, because they are the agents. They made a contract, and they feel like they obtain the subsidies. They engage with the company and hire workmen or the employees for short time period. And this is a right. This is the right has been given in the law that there's no concept of contract. But what they do that, because of enforcement of the rights. If you are if a company hire someone directly, he's a permanent employee, permanent workman. So he would claim for the leave, he would claim for the wages, he claim for the bonus, he will claim for the rights, other rights is embedded rights which are, but this is a practice, that the company hire the agent and the agent hires to the contract employees for a for hourly basis, for a monthly basis, because they cannot claim the rights. This is the practice. Okay. Hello, any question? Yeah? Okay. Yes. Hello.
Yes, sir, thank you. My sincere and on the behalf of Dynamic Classes Association, thanks for your exceptional presentation on session. Your insight and expertise made a significant impact, and we are grateful for your valuable contribution. Thank you again for sharing your knowledge and making our session a success. Hope to welcome you again, sir, in future. Thank you, sir. Thank you so much.
Thank you, Sonia. Thank you, the Sajad, and your team. And I'm very pleased to hear that you are doing well, and it's a great contribution for the students and the law practitioners. And I wish you good luck to all of you. And thank you very much. Thank you.
Yes, sir,
Sir,
thank
we
you.
have a
Thank you.
question from the audience.
Okay, most welcome. Yes.
Sir, they are asking, what is the social security for the workers?
Yeah, social security, the contribution of the employee and employers, and they are in a certain circumstances, employees, is safe and he has no any expected amounts, and they contribute to each other, the company contribute and the pay deposit amount in social security, and then in the end or the meanwhile, if the workman is sick, or he got accident, or there are a number of the benefits of the social security. As an institution is developed and established by the government of Sin, and we need to aware the workmen that they are protected, and then they need to approach the social security department, and once they are the registered, the company, and the company has to send these data to regularly send the data to the social security department for getting benefits, or after attending the age of the 60, he has or she has to claim or his right from the social security. Okay.
Yes, sir, thank you for such informative session. Thank you so much. Allah Hafiz, sir.
Allah Hafiz. Thank you so much.